President.
The honourable member.
Thank you, Mr. President. I rise to speak in support of the Justice Legislation Amendment Bill 2017. This bill makes a number of amendments to improve criminal enforcement through addressing gaps in existing offences, overcoming obstacles to the successful prosecution of certain offending behaviour, and aligning relevant offences to create a consistent penalty regime for similar offences. This bill seeks to prescribe petrol as a destructive substance when used to assault an individual. Items 1 and 2 of Schedule 1.5 of the bill amend the Crimes Act 1900 in order to address gaps and obstacles to the successful prosecution of certain criminal behaviour, as identified by the Office of the Director of Public Prosecutions. Item 1 of Schedule 1.5 amends the Crimes Act 1900 to clarify that petrol is a destructive substance for the purpose of the offence of using an explosive substance or corrosive fluid in Section 47 of that Act. This offence covers conduct where a person throws a destructive or explosive substance on a person with the intent to burn, maim, disfigure, disable or do grievous bodily harm to the victim. One common sense application of this offence is where a person throws petrol on another person and threatens to set it alight. However, contrary to the ordinary understanding of petrol as an explosive substance, in technical scientific terms, it is only explosive under certain conditions. The amendment aims to circumvent a possible argument along these lines by clarifying that, for the purposes of this offence, petrol is understood as an explosive substance. The amendment will remove this technicality as a potential difficulty in future prosecutions for this offence. It will ensure the offence works as intended, and that if petrol is thrown onto someone, the physical element of the offence in Section 47 is made out. This bill seeks to provide a statutory alternative to prosecution under Section 193E. Item 2 of Schedule 1.5 makes an adjustment to the money laundering offences in the Crimes Act 1900. Under Section 193C, bracket 1, it is an offence to deal with property valued at $100,000 or more where there are reasonable grounds to suspect that the property is the proceeds of crime. Section 193C, bracket 2, provides the same offence but applies where the property is valued at less than $100,000. It can sometimes be difficult for the prosecution to prove beyond reasonable doubt the exact value of the property for the purpose of these offences. To ensure that this does not lead to a prosecution failing, the bill amends Section 193E to provide that the offence of dealing with property valued at less than $100,000 is a statutory alternative to the offence of dealing with property valued at $100,000 or more. The practical effect of this will be that if a person is charged with dealing with property valued at $100,000 or more, but the prosecution cannot prove beyond reasonable doubt that the property was worth that amount, the person can instead be convicted of the lesser offence of dealing with property worth less than $100,000. The amendment will ensure that the structure of these offences does not create an obstacle to successfully prosecuting a person for money laundering. Mr. President, this bill seeks to align similar offences and create a consistent penalty regime. Schedules 1.1, 1.4 and 1.8 of the bill align relevant offences and will create a consistent penalty regime for similar offences across different pieces of legislation. This bill seeks to clarify a show cause offence for bail purposes. Schedule 1.1 implements a proposal by the Bail Act Monitoring Group to clarify that the offence under Section 50B of the Firearms Act 1996 is a show cause offence for the purposes of bail. The offence in Section 50B relates to giving a person possession of a firearm, where the recipient is not an authorised user where the recipient is not authorised to possess that firearm. An example of where this offence may apply is where the owner of the firearm lends it to another person who is not authorised to have the firearm. This conduct can occur as part of organised crime or terrorist activities. Under the Bail Act 2013, certain serious offences are show cause offences. That is, a person charged with one of these offences will be refused bail unless the person can show cause for why their detention is not justified. The Bail Act already specifies that serious firearms offences that involve illegally acquiring or supplying a firearm are show cause offences. It was intended that the offence in Section 50B of giving possession of a firearm would also be a show cause offence, because it comes under the idea of supplying a firearm. However, a recent decision of the Supreme Court highlighted that the offence is not actually covered, as it technically relates to giving possession of a firearm rather than supplying it. The amendment in Schedule 1.1 of the bill fixes this unintended anomaly by specifying that an offence of giving possession of a firearm is also a show cause offence for the purposes of bail. This will correct a drafting oversight, as the show cause test was always intended to apply to serious firearms offences. Mr. President, this bill seeks to align penalty for possessing a knife on court premises. Schedule 1.4 amends an anomaly in the maximum penalty for the offence of possessing a knife on court premises. Under Section 8 of the Court Security Act 2005, it is an offence to possess a restricted item in court premises without a reasonable excuse. The current penalty of this item is a fine of 5 penalty units for a first offence, 10 penalty units or imprisonment for 12 months or both for a second offence, and 20 penalty units or imprisonment for 2 years for any subsequent offence. The offence is similar to the offence in Section 11C of the Summary Offences Act 1988, which makes it an offence to have custody of a knife in a public place or school without a reasonable excuse. The maximum penalty for this more general offence is a fine of 20 penalty units or imprisonment for 2 years or both. This bill amends the Court Security Act 2005 to bring the maximum penalty for possession of a knife in court premises into line with the offence in the Summary Offences Act 1988. The simpler maximum penalty of a fine of 20 penalty units or imprisonment for 2 years or both will apply. This amendment was proposed by the Chief Magistrate of the local court and will ensure there is a consistent penalty regime in place for these two very similar offences. The court will be able to take a person's criminal history into account when sentencing for the offence under the Court Security Act 2005. So where it is a person's first offence, they will receive a lower sentence, all other things being equal, than a person who has previously been convicted of an offence of this nature. Mr. President, this bill seeks to correct an oversight from the definition of a drug trafficking offence. Item 1 of Schedule 1.8 amends the Criminal Assets Recovery Act 1990 to include the offence under Section 23A of the Drug Misuse and Trafficking Act 1985 as a drug trafficking offence for the purposes of the Criminal Assets Recovery Act 1990. Section 23A relates to enhanced indoor cultivation of prohibited plants in the presence of children. Currently, similar offences within Part 2, Division 2 of the Drug Misuse and Trafficking Act 1985 are defined as drug trafficking offences for the purpose of the Criminal Assets Recovery Act 1990. Section 23, for example, relates to offences with respect to prohibited plants and includes an offence for cultivation of a prohibited plant. Mr. President, I commend the bill to the House. Thank you.